Most people believe they understand their rights during a police encounter. They've watched the videos, heard the phrases, maybe even memorized a line or two from television dramas. But in real-world traffic stops and street encounters, many individuals unknowingly waive powerful constitutional protections within seconds of an officer beginning a conversation. According to court records and legal scholarship, some of the most consequential admissions in criminal cases happen not inside interrogation rooms, but roadside, casually, and voluntarily. But here's the question. When officers use certain psychological techniques during routine encounters, are they crossing a constitutional line, or are they simply using lawful investigative tools? Let me know your answer in the comments below. Across the United States, police officers are trained not only in enforcement tactics but also in communication strategies. These strategies are documented in training manuals, public testimony, court decisions, and academic research. According to publicly available law enforcement training materials, officers are instructed to gather information efficiently, assess risk quickly, and establish control of an encounter early. None of these goals are inherently unlawful. In fact, the Supreme Court of the United States has repeatedly acknowledged that officers may use certain deceptive or strategic questioning methods during investigations. One of the most cited cases in this area is Miranda v. Arizona, decided in 1966. In that case, the court held that suspects must be informed of their rights before custodial interrogation. However, subsequent rulings clarified that many police encounters do not qualify as custodial interrogation. A routine traffic stop, for example, is generally considered a temporary detention under the Fourth Amendment, not full custody under the Fifth Amendment. That distinction is critical. According to the court's ruling in Berkemer v. McCarty, roadside questioning during a traffic stop typically does not require Miranda warnings unless the situation escalates into formal arrest or its functional equivalent. As a result, officers may ask questions such as, "Do you know why I stopped you?" or "Where are you coming from tonight?" without first advising a person of their right to remain silent. Legal analysts often note that this is where the first so-called trick appears. Not because it is illegal, but because many individuals misunderstand the legal framework. When an officer asks, "Do you know why I stopped you?" the question may appear conversational. However, according to criminal defense attorneys and former prosecutors interviewed in public legal forums, this question often serves an evidentiary purpose. If a driver responds, "I was probably speeding," that statement may later be introduced as an admission. One interpretation is that the officer is simply giving the driver an opportunity to speak. Another perspective raised in court is that the phrasing encourages self-incrimination without overt pressure. Under the Fifth Amendment, individuals have the right not to incriminate themselves. However, that right must generally be invoked. In Salinas v. Texas, the Supreme Court held that silence alone does not automatically invoke the Fifth Amendment in non-custodial settings. In other words, a person may need to clearly state their intention to rely on their constitutional rights. This leads to a phrase often recommended by defense attorneys: "I respectfully decline to answer any questions and would like to speak with an attorney." According to legal experts, the clarity of the request matters. Courts have ruled in cases such as Davis v. United States that ambiguous references to an attorney may not require officers to stop questioning. Saying, "Maybe I should get a lawyer," may not be sufficient. Saying, "I want a lawyer," is clearer. Another commonly discussed investigative tactic involves consent searches. The Fourth Amendment protects against unreasonable searches and seizures. However, consent is a well-established exception. If an individual voluntarily consents to a search, officers typically do not need a warrant or probable cause. Court records show that officers frequently ask, "You don't mind if I take a quick look inside your vehicle, do you?" The phrasing may sound informal. According to Schneckloth v. Bustamonte, the Supreme Court ruled that officers are not required to inform individuals of their right to refuse consent. The key legal question becomes whether the consent was voluntary under the totality of the circumstances. One interpretation is that this promotes efficient policing. Another perspective raised in suppression hearings is that many individuals feel pressured even when no direct threat is made. The phrase that often changes the legal landscape is simple: "I do not consent to any searches." Legal analysts emphasize that this statement does not obstruct justice, does not imply guilt, and does not create probable cause. It simply preserves constitutional protections. It is important to clarify that refusing consent does not guarantee officers will not search. If officers develop probable cause independently, they may proceed under established exceptions, such as the automobile exception. But the refusal itself cannot be used as evidence of wrongdoing. This is for informational purposes and not legal advice. Another investigative method involves what courts describe as voluntary encounters. According to United States v. Mendenhall, a police interaction becomes a seizure only when a reasonable person would believe they are not free to leave. Officers may approach individuals in public spaces and ask questions without triggering Fourth Amendment protections, so long as the encounter remains consensual. In practice, this can blur lines. An officer might say, "Mind if I ask you a few questions?" The tone may be polite. The setting may be public. Legally, unless the officer asserts authority or restricts movement, the person may be free to decline and walk away. However, many individuals do not realize they have that option. Defense attorneys frequently advise asking one clarifying question: am I being detained or am I free to leave? If the officer states that the person is free to leave, the encounter remains voluntary. If the officer states that the person is being detained, constitutional standards for reasonable suspicion apply under Terry v. Ohio. This moment can become a key turning point in litigation. Body camera footage in numerous cases has shown individuals continuing to answer questions even after officers confirm the interaction is voluntary. Courts generally view such statements as admissible. Another commonly discussed tactic involves minimizing language. Interrogation research, including studies cited in appellate opinions, shows that officers may say things like, "We just want to clear this up," or "This isn't a big deal." According to Frazier v. Cupp, certain forms of deception are legally permissible during interrogation. One interpretation is that these strategies help uncover truth. Another perspective raised by legal scholars is that psychological pressure may lead to unreliable admissions. The constitutional safeguard remains the same: clear invocation of the right to remain silent and the right to counsel once custody begins. In many appellate cases, suppression motions hinge on whether a suspect clearly invoked those rights. Courts examine exact wording, tone, and context. A statement such as, "I don't think I should say anything," may be deemed ambiguous. A statement such as, "I am invoking my right to remain silent," is clearer. Key turning points often occur within seconds. A driver admits speeding. A passenger consents to a search. A suspect continues talking after partial invocation of rights. Each of these moments can later shape courtroom outcomes. According to Department of Justice publications and legal treatises, effective communication between citizens and law enforcement depends on clarity. Officers are trained to gather evidence lawfully. Citizens are entitled to assert rights lawfully. The constitutional system assumes both sides understand the framework. Given these facts, the broader issue becomes less about tricks and more about legal literacy. Courts have consistently held that constitutional protections exist, but they must often be clearly invoked. So here's the larger question. If the law allows officers to use strategic questioning, but also allows citizens to assert their rights clearly, where does responsibility ultimately lie? Should individuals be expected to know the precise language that protects them, or should procedural safeguards go further? Share your thoughts in the comments. If you found this legal breakdown helpful and want more in-depth analyses of real police encounters, constitutional rights, and courtroom precedents, consider subscribing for future investigations.